Welcome back to RR Corporates. ROC Hyderabad has imposed a penalty for non-appointment of independent directors. In this video, I will cover the recent order, that is 18th September 2025 by the ROC. And the key issue is the non-compliance with the section 149, subsection 4 of Companies Act 2013. Failure to appoint two independent directors from 2015 to 2002 of Companies Act 2013. That is a general penalty clause. Penalty for the company 3 lakh rupee, and other directors there is 1 lakh rupee each. Subject to period of default is a cap. It came to 6 lakh rupees. I also explain the section, what section 149 subsection 4 and rule 4 required regarding independent directors. Why the RD, additional director, treated this, the company filed a compounding application, but RD treated this as a continuing offence, so he adjudicated the matter. And penalty structure, we also discussed and we will discuss under section 172, 454, subsection 5 and 6. So this case highlights the seriousness of the compliance with corporate governance provisions and the risk of the penalties, not only on the company and their officers. Company default, that is a failure to appoint two independent directors from 1st April 2015 to 14 March 2021. So company filed a suit of RD, Regional Director, Hyderabad, clarified that since it was a continuing offence, it cannot be compounded, it is only adjudicated. So the legal provision involved is section 148, 149, 4 mandates independent directors in listed companies and public companies, certain public companies. So rule 4 of Companies Appointment and Qualification of Directors Rules 2014, which defines categories. So section 172, general penalty for contravention, that is 50,000 rupees and plus 500 rupees per day, subject to maximum 3 lakh rupees for company and 1 lakh rupees for officers. Highlights is the period of default, different for each director. Penalty imposed on the company 3 lakh and directors totally, the director totally. So the compliance and payment, penalty to be paid within 90 days via MCA e-Adjudicating portal, and penalty must be paid from personal income of the officers. Appeal provision is there within 60 days. If they want to appeal, the non-appointment of independent directors is a serious violation. This case reaffirms the importance of the corporate governance compliance. Companies and directors must proactively comply to avoid heavy penalties. Now I will take you to the official website where the order, I will share you the order. This is the order, adjudication order. This is available on the website, MCA website, Government of India, Ministry of Corporate Affairs. All adjudication orders, all orders available. This is the dated 18/9/2025. Here you can see it is a very recent adjudication order. ROC adjudication officer. Here the company details are given, individual director details also given. And the provision of the act here given, if a company is default in complying with any provisions of this chapter and for which no specific penalty or punishment is provided therein, the company and every officer of the company who is in default shall be liable to a penalty of 50,000 rupees, and in case of continuing failure, further penalty of 500 rupees each day, during which such failure continues, subject to maximum 3 lakh rupee in case of a company and 1 lakh rupee in case of officer who is in default. Facts of the case, just I explained, and this is the penalty table on the company 3 lakh. And other directors, each director, it differs from director to director. So this is what the order. It is available on OMC website. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss latest updated videos. Thank you.